warahmatullahi wabarakatuh. My name is Siti Faizah binti Yusof. My matric number is 067901. I will discuss about the legal basis for search and seizure operations under Shariah law. Shariah law allows search and seizure. This is allowed in cases of crime or violations of Islamic law. The specific varies based on each interpretation and its implementation. This is also taken from the Quran verse, hadith, and juristic interpretation. For an example, in the case of theft, or in the case of adultery, the Sharia law may also allow the authorities to conduct an inspection of individual property or goods to collect evidence. However, this action usually required adherence to procedural safeguards to ensure fairness and protect individual rights. Okay, legal bases have three, which is Al-Quran, Hadith, and juristic interpretation. You can see from my back about the Al-Quran, Hadith, and juristic interpretation. Okay, based on section 52 on Sharia Criminal Procedures, Federal Territories Act 1997 grants authority to the conducting officer to confiscate any discovered item during the search process. This section is implied to provide the rights of the religious enforcement officer or the police officer to conduct such search and seizure needed. Okay, after that, about condition of search. The condition of conducting a search under the Sharia law are aimed at safeguarding individual rights, the existence of justice, and maintaining the rules of law within the framework of Islamic legal principles. It reflects the principles of justice, accountability, and respect for human dignity inherent in Islamic legal tradition. The important condition required to ensure such protection when conducting search, such as authorization and compliance with the law, probable cause, and reasonable suspicion, reducing intrusive activities, respecting the privacy and dignity of the individual, prior notifications and clarifications, transparency and documentation, and last but not least is the right to challenge. After that, about section 52 based on Sharia Criminal Procedure, Federal Territories Act 1997, if someone with arrest authority, such as religious enforcement officer or police officer, suspect that a person they are seeking has entered or is in a certain location, the person in charge of the place must allow them to enter and aid with a search when requested. However, this is same as a subsection 2 also. That's section 13, where it states that any religious enforcement officer or other person authorized with lawful enter the place in regards to the purpose of making an arrest may break open a place to liberate himself where things are detained therein. In conclusion, items that have the potential to be hidden by someone can be examined by either a religious enforcement officer or a police officer, at least with the rank of inspector, which they will be detained until the search is complete. Thank you.
Next condition for seizure. According to Yusof 2020, both search and seizure are really important procedure before having a trial in a court after receiving some complaint by any person. And according to section 15 of Sharia Criminal Procedure Federal Territories, it mentioned about for both search and seizure, either he is unwarranted and cannot be provided for the taking of bail or be provided for the taking of bail, but the person arrested cannot furnish the bail, or in another situation which the person without any warrant and unable to furnish bail. And according to section 52, tells us the condition of seizing is a list of all things seized shall be prepared by the officer or other person who making the search and must be signed by him. And in addition, section 16 tells us about REO, religious enforcement officer or police have the right to seize any offensive weapon.
Assalamualaikum, I am NAZAHA binti IBRAHIM, number matric 065773. Today, I want to present about the limitations of search. First limitation is about the searcher not needing to detain arrested people as long as they don't fight back or run away. If the situation causes a person to be searched, the arrested person should be searched by someone of the same gender as a sense of respect. Second limitation, if the religious enforcement officer needs to arrest the person who needs to examine, the officer is allowed to search and seize all belongings of the person except the clothes he was wearing at the time, and all the confiscated items must be kept in a safe place. Other than that, the court has the power to choose and determine a certain part of the place to be searched, and the persons responsible for the search can only search the place determined by the court. The last limitation, that when a place is searched, the occupier or the representative of the occupier is allowed to present during the search. A list of confiscated and signed search item can be handed over the occupant or their representative at their request. That's all from me. Thank you for hearing.
Next, limitation for seizure. According to Section 15 of Shariah Criminal Procedure Federal Territories, same goes with condition for seizure. It mentioned about for both search and seizure, either he is under bail or not, and seizing all needed except where in place them in safe custody. So the conclusion, it is proven that the procedure of search and seizure whether a person of things have its own conditions and limitations as provided by the Sharia Criminal Offences Federal Territories Act 1997. These conditions and limitations are meant to preserve the individual rights which states in the Article 5 of the Federal Constitution. Hence, it is vital to the religious enforcement officer or police to know the rights before conducting any procedure such as search and seizure. Thank you.
Bismillahirrahmanirrahim. I am IZATUL NAJIHAH binti MUSTAFA, matrix number 065453. So we move on to section B, question 1, which is this question is related to an offense in Sharia criminal procedure. So we look into introduction. What is an offense? An offense is an act or omission made punishable by any written law, prescribes offences against precepts of Islam and over which the court has jurisdiction. So there are two types of offences. First is seizable offence, the second one is non-seizable offence. So what is seizable offence? Seizable offence is defined under Section 2 Sharia Criminal Procedure Enactment of Terengganu as an offence punishable with imprisonment of 1 year or more, which the Sharia enforcement officers, or also known as REO, or police officers may ordinarily arrest without warrant. While non-seizable offence is also defined under the same section as an offence punishable with imprisonment less than a year or with a fine only, which Sharia enforcement officers or police officers may not ordinarily arrest without warrant. So in this case, Remy, a 26-year-old man, has been charged with the offence of disrespect for Ramadan. And according to him, this offence is a seizable offence. He also informed that his case will be tried at Sharia High Court of Terengganu.
My name is NURAIDA binti AZMI, matrix number 065433. I will proceed with the issues of this case and the application of law. There are two main issues that we can address from Remy's case. The first issue is whether the act of disrespect for Ramadan was a seizable or non-seizable offence, and the second issue is whether the Sharia High Court has jurisdiction over this case. The laws applied in this case contains 5 main laws. The first one is from Surah Al-Baqarah verse 183, which provides the obligation on Muslims to the fasting during the month of Ramadan. The second law is section 19 of the Sharia Criminal Offences Ta'zir Terengganu Enactment 2001, which provides the offence of disrespect for Ramadan. The third application of law is Section 2 of Sharia Criminal Procedure Terengganu Enactment 2001, which interprets the seizable and non-seizable offence. Meanwhile, the fourth and the fifth application of law are Section 12 subsection 2A and Section 11 subsection 3A of the Sharia Court Terengganu Enactment 2001. Section 12 subsection 2A mentioned the jurisdiction of the Sharia Subordinate Court, while the Section 11 subsection 3A mentioned about the jurisdiction of the Sharia High Court.
Next, the analysis. According to the Enactment Number 7 of 2001 Sharia Criminal Offences Ta'zir Terengganu, Enactment 2001 Section 19, the disrespect for Ramadan, provided punishment fine not exceeding 1,000 ringgit or to imprisonment for a term not exceeding 6 months or to both, and for a second or subsequent offence to a fine not exceeding 2,000 ringgit or to imprisonment for a term not exceeding 1 year or to both. While looking at provision of Section 2, an offence with punishment imprisonment of less than 1 year will be a non-seizable offence. There also Section 12 of Sharia Court Enactment in its criminal jurisdiction stated clearly that it has jurisdiction to hear an offence which the punishment is thus not exceed 3,000 ringgit or imprisonment for a term of 2 years or both, and may impose any punishment provided for such offences. In conclusion, Remy has committed a non-seizable offence, which means that the Sharia High Court does not have jurisdiction over the case as it is under the jurisdiction of Sharia subordinate court. If it was proven that Remy has been committed the offence, he will be liable to an offence imprisonment or both. That's all from me. Thank you.